Hello, it's Caitlin Jenkins, the family law vlogger here. This is the next in the stages of divorce vlog, and today I'm looking at what first appointments are in financial remedy proceedings and how to prepare for them. So what we're talking about is financial remedy proceedings, which are the court proceedings that sometimes happen between a couple when they're getting divorced if they haven't been able to sort out their finances between them in other ways, such as mediation or through their solicitors. So once somebody's started the financial remedy proceedings, then each party has to fill in the Form E, the financial disclosure form, and there are other vlogs about this. And then there may be some questionnaires, which again, there's a separate vlog about. And then there's the first appointment, or sometimes called the first directions appointment. That is a court hearing, usually in person, sometimes online. And unless agreed or directed otherwise by the court, and it's usually a direction from the court rather than just the parties agreeing, both of the parties, so the couple, need to attend that first hearing. It's in front of a district judge in the local court where the proceedings have been issued. So the hearing is usually listed for about an hour, and the parties have to put in, if they're represented or by solicitors or barristers or not, they have to put in some of the paperwork, they have to put in a court bundle, and the details of that will be the subject of a separate vlog. So the judge on that day is looking at what information and evidence has been provided thus far, so in the Form Z, and in the subsequent documents, so in any questionnaires that have been raised, and in the ES1 and the ES2, which are the case summary and the schedule of assets, which I've explained in previous vlogs. So the purpose of the first appointment is for the judge to assess and take stock. What information have we already got? What are the parties agreed on? What further information does the court and the parties need to be able to progress to the further stage in the court process, which is the negotiation stage, which is the second hearing, the financial dispute resolution hearing, the FDR. So the judge at the first appointment is not making decisions about the merits of the case, is not going to impose an outcome on people in terms of what happens to the overall assets for the long term, but the judge will look at what further evidence is needed. So what do I mean by that? So what I mean by that is probably two different categories, really. Either information that one of the parties or both of the parties need to provide, or information that a third party might need to provide, so valuation evidence. So what is a judge looking at in terms of information that one of the parties might need to provide? Well, if there's a dispute about questionnaires that have already been filed, so a list of questions that one person has asked of the other based on the information in their Form E, then the judge at the first hearing can go through that list of questions and say which questions should be answered. Now, they may say that a question is irrelevant, or they may refine the extent of the question. So, for example, if somebody had asked for 3 years of bank statements, the judge may try to understand why somebody wants to go back that far, but then make a direction as to whether it should be 3 years or a different period of bank statements. So the judge will look at any questionnaires and provide a timescale within which those questions need to be answered. And what of information to be obtained from third parties? Well, usually what we're talking about here is valuation evidence. So if the couple don't agree on the value, say, of a house, then one of them may be saying we should be getting an independent third-party expert to value the house as a single joint expert, chartered surveyor. And the judge will consider the merits of whether that's necessary, whether it's proportionate. They'll consider information that one of the couple will have put in about through their solicitors, usually about how much that valuation would cost, who would be the appropriate expert. And if the judge feels that that information is necessary and proportionate to enable the parties to progress their negotiations, then they'll direct that evidence. Same sort of thing applies in relation to bigger valuations, like valuations of businesses or valuations of land. If it's a farming business, the judge might direct, if one of the parties asks for it because there's a dispute about, say, the value of the land owned by the farm, the value of potentially premises on the land, so maybe some grain store or some plant, a plant that provides support to the business, if it's a manufacturing business, for example, and then a business valuation as well, so an accountant to actually value the business once the assets of the business have been valued. And we'll do some separate vlogs about the topic of valuation. So overall, therefore, at the end of a first appointment, the judge will have given some directions about any further evidence that's needed, whether it's from the parties, whether it's single joint expert valuation, and they'll also direct any other evidence, for example, from a pension report, and we've done some separate vlogs about pension reports. The judge will also set a timescale or a timetable for the next step in the proceedings. So it'll timescale all that further evidence, and then it'll timetable a financial dispute resolution hearing, which can be a second court hearing, or it can sometimes be done as a private financial dispute resolution hearing, a private FTR, which is effectively doing the same job as a court, but doing it privately at a timescale to suit the parties. So that's what the first directions appointment or the first appointment is about. There are circumstances in which you can get rid of and negate the need for a first appointment under what's called the accelerated procedure. And I'll do a separate vlog about the accelerated procedure and what's needed to do that. But primarily the starting point is, unless agreed otherwise or directed, both parties will need to attend the first appointment because the court will want to give further directions to make sure that the case is progressing towards the stage of the negotiation. As always with the Family Law Vlog, I can only give sort of general information and about what these sort of aspects mean. And if you need advice or further information about your particular circumstances, then please do contact me or one of my colleagues in the Mills Reeve Family and Children team, and we'll be happy to help you. Thank you.